Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have. Now, we are going to jump into part 2 of R. Kelly's motion for a new trial focusing on his attorney's potential conflict. So we've already done a video on part 1, which talked a lot about ineffective assistance of counsel based on voir dire and some of the jurors that ended up getting on the jury. That seems mind-boggling. But today, we are going to focus our attention on the second part of that. Let me pull it up here. I think this is it. Yes, it is. All right. So part number 2, the defendant is entitled to a new trial where one of his trial attorneys labored under a disabling conflict of interest as a result of her simultaneous representation of the defendant and the government's star witness, Jane, that was imputed to her entire defense team. So just to set the stage for this, if a lawyer has a conflict of interest, that does not automatically give you a new trial. It has to be an unwaivable conflict of interest that prejudiced the case, okay? Because you're going to see throughout, basically everybody agrees there is a conflict here, including the judge, but we need to determine if the conflict rises to such a level that it should not have been allowed to be waived and it affected the outcome of the case. So first, we start with a little bit of background. The defendant is entitled to a new trial where he was denied Sixth Amendment constitutional guarantee of conflict-free counsel. Mere weeks before the commencement of the trial, it was discovered that one of defendant's attorneys, Ms. Becker, may be suffering from a conflict of interest because of her prior representation of the government's key witness, Jane. And just mere weeks before trial, they actually had a hearing on this where the judge ended up allowing her to continue as R. Kelly's lawyer. We'll talk about why later. Consistent with its obligations, the court conducted a Cursio, is that how you say that? Cursio hearing, and concluded that Ms. Becker had entered into an attorney-client relationship with Jane while she was representing the defendant. Although this conflict was an unwaivable conflict, the court permitted the defendant to waive it. Because the defendant was denied conflict-free counsel, he deserves a new, I will read it. Who likely possessed information that could have been used to discredit Jane's testimony, but was unable to utilize this information without revealing attorney-client communications. Defendant was prejudiced by this conflict. So there's a couple things to unpack here. First, the reason the judge allowed him to continue is because he voluntarily and knowingly waived this conflict after the judge asked him a number of questions to make sure that he wanted to waive this conflict, including asking him if he wanted to talk to another lawyer, but he decided to waive it anyways. Additionally, they're saying one of the prejudices was he was unable to utilize information without revealing attorney-client communication. But if she wouldn't have been his lawyer, the other lawyers wouldn't have known about these communications with Jane either, right?
Yeah, that's true. The Cursio hearing is really very simple. The question is, does the defendant knowingly and intelligently waive the conflict? That's as simple as it is. Meaning, did the defendant know? And based on the information that was provided to the defendant, did he have enough information to be able to knowingly waive the conflict? That's all that is.
Right. And then once he says he wants to waive, they ask him a ton of questions. Are you sure? You could have a different lawyer if you want to. We can continue this case if you want to. You are not going to be allowed to use this as a reason for appeal. Do you understand that? Those are all questions that are asked. Once again, this is a good motion. As you read it, you're going to nod your head and say, yeah, this makes sense. This makes sense. But we have to actually understand how this entire process works. The Sixth Amendment mandates that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The right to counsel includes a criminal defendant's right to be represented by the counsel of his choice, which is another big portion of this. He chose Ms. Becker and chose to keep her even after finding out about this conflict. However, this qualified right is supported by, among other things, the Sixth Amendment right to effective assistance of counsel. A defendant's Sixth Amendment right to effective assistance of counsel includes the right of representation by conflict-free counsel. A per se, meaning automatic, conflict of interest exists where the attorney was not licensed to practice law and he failed to satisfy a substantial requirement of admission to the bar. Fine, we don't have that here. And 2, where the attorney was implicated in the defendant's crime.
That's where they're hanging their hat.
The per se rule applies when an attorney is implicated in the crimes of his or her client since in that event, the attorney cannot be free from fear that a vigorous defense should lead the prosecutor or the trial judge to discover evidence of the attorney's own wrongdoing. And we'll get to what that is specifically in a little bit. An attorney has an actual as opposed to potential conflict of interest where during the course of the representation, the attorneys and the defendant's interests diverge with respect to a material, factual, or legal issue or to a course of actions. While a defendant is generally required to demonstrate prejudice to prevail on a claim of ineffective assistance of counsel, this is not so when counsel is burdened by an actual conflict of interest. I think that is incorrect just by the case law. Prejudice is presumed under such circumstances. In the case at bar, defendant is entitled to a new trial where his attorney labored under a per se and or actual conflict of interest that could not be waived. At the hearing, July 15th, 2021, just weeks before the trial, Jane's prior attorney, Ms. Rodriguez, this is interesting. Ms. Rodriguez disclosed to the court that she was previously retained by Jane and another potential government witness, Savage. Rodriguez met defendant's attorney, Ms. Becker, in person at a bond hearing at the Dickerson Center in July of 2019. Ms. Rodriguez expressly told Ms. Becker that she represented Jane and Savage and instructing her not to contact Jane. Ms. Rodriguez provided a text message to the court that showed that she, Rodriguez, texted Ms. Becker stating, "I don't want the lines blurred regarding our role, and I think that they are already blurred." That's bad for Ms. Becker. "Please do not contact them at all without my knowledge." Rodriguez told the court that she later learned that Ms. Becker had been contacting Jane and Savage. According to Rodriguez, Jane suggested that she was getting advice from Becker in connection with how to handle the media. Rodriguez declined to divulge further information about her conversation with Jane, since in fact they are protected by attorney-client privilege, but stated that her representation formally ended when she received instructions signed by Jane telling her to provide her attorney file to her new attorney. So why don't you talk a little bit about what that looks like when you switch lawyers and you get their file? What does that mean, and what has already happened by the time that occurs?
Right. What basically happens is if you are allowed to change lawyers whenever you want, you're not obligated to keep anybody. The key, though, is once the lawyer that is currently representing is notified about replacement, they provide whatever materials they have that are case relevant and send them over to the new lawyer. Because at that point, you still, as the old lawyer, have an obligation to that client for confidentiality and other things. But at the same time, your obligations to the client going forward are done.
Right. And that really can't happen until you've actually hired that other person.
Mm-hmm.
Ms. Becker confirmed that she had communications with Jane. The government also confirmed that Jane had told prosecutors that she had a lengthy meeting with Ms. Becker in August of 2019. The government revealed that in their conversation with Jane, Jane revealed information to the government that she received from Ms. Becker that the government viewed as adverse to the defendant. So Jane, the victim, told the government things that were bad for the defendant, R. Kelly, that she learned from Becker, this lawyer that they both had.
Which I think implicates the prosecutors, but we'll talk about that.
After considering statements made by Ms. Rodriguez, the court noted that Ms. Rodriguez stated Ms. Becker had given her clients legal advice that conflicted with the advice that Rodriguez had given her client, meaning Becker telling her something different than Rodriguez, probably because Becker also represents R. Kelly. This court seemingly concluded that Becker had formed an attorney-client relationship with Jane while she was representing the defendant, evidenced not only by Ms. Rodriguez's statements, but by the fact that Jane instructed Rodriguez to send her file to Ms. Becker. As we said, usually that means you've hired the other lawyer. The government further pointed out that Ms. Becker might suffer from a so-called Fulton conflict, which arises when a lawyer is accused of misconduct. And again, accused of misconduct doesn't necessarily mean it's true, whether true or not. In those scenarios, the lawyer may violate his or her duty of loyalty to her client by prioritizing her own interest in defending herself against accusations of misconduct. Why don't you explain that?
All right. Fulton, the case basically says that, and I'll show you a little bit of background. A lawyer was apparently involved in some heroin smuggling ring and represented a defendant who was also part of the heroin smuggling ring. And the court made a determination that that lawyer had an inherent conflict because if you're implicated in a crime, you can't, give good advice to your client because you're always trying to protect yourself. That's what they're saying. So the key is, if in fact there was a perceived conflict that Becker had, she at that point places herself in a position where she's protecting herself and can't, give all of her attention to R. Kelly.
All right. Let's see here. This court acknowledged that Becker did suffer from a conflict. Like I said, everybody seems to agree there was a conflict, but that it amounted to a conflict that could be waived and mitigated by ensuring that Becker did not conduct the cross-examination of Jane. Yeah, that would be bad.
Yeah.
This court afforded the defendant the opportunity to consult with a third-party lawyer and admonished him before accepting his waiver of conflict-free counsel. Why don't you talk about whether or not you think that the fact of not letting her conduct cross-examination was actually enough of a protection?
I don't think it is. And the reason I don't think it is because if the court has made a determination that there's a conflict, by simply not questioning the lawyer, simply not questioning Jane, whose real name, by the way, is Miss Clary, is Ariel Clary.
Who most of us know by the Surviving R. Kelly documentary because she was one of his girlfriends that was still supporting him at the time.
Right. The key, though, is let's just say you were going to cross-examine her instead of me. I can pass you notes.
Exactly.
I know things from that attorney-client
the
relationship.
Entire preparation, opening statements, closing arguments.
I can, which is good for R. Kelly, I can guide the litigation to the way it needs to be because I have information from Jane, which in and of itself isn't bad because any government witness can call a defense lawyer and say, hey, I'm not going to be cooperative.
But it's privileged conversation.
But it's privileged when you're attorney-client privileged communication.
And the other thing about proving prejudice is if I know something about the victim that's going to help R. Kelly, that doesn't prejudice, meaning hurt him. And if I represented the victim at some point or simultaneously or whatever, she's still going to testify against you whether or not this conflict exists. So if I would have been off the trial, that conflict would have still existed. That witness is still going to testify against you. So I'm not finding the prejudice here, I think, is my issue with this.
Against R. Kelly.
Right.
Yeah.
Even though I do think that there was a conflict here, but I kind of feel like the waiver was probably knowing and appropriate, and there was not prejudice from it. It's kind of where I'm leaning.
I flip-flopped on this. When I heard the facts, I guess as a lawyer, it kind of freaked me out because I don't think I'd ever want to be in this position.
You should never do this.
This is bad.
This is really bad.
But the truth is, whoever is being hurt is not R. Kelly. It's Jane. She's the one whose information is being used in order to further R. Kelly's position. So I think R. Kelly, happy to waive it. Yeah, the fact that I know everything there is to know about what this witness is going to say and what they've done, all the bad stuff, is because of this relationship. I don't care. That's fine.
Right.
Which is why he, in fact, waived the conflict.
Defendant is entitled to a new trial where his attorney, Ms. Becker, labored under a per se or actual conflict of interest could not be waived. First, as the government pointed out, Ms. Becker seemingly suffered from a Fulton conflict, a per se conflict, where there is no question that by communicating about the case with the government's key witness, notwithstanding that the fact that the witness had her own counsel and did not consent to the communications, she opened herself up to accusations of misconduct, meaning the misconduct of Becker was that as a lawyer, you're not allowed to give advice and basically work for a client when you know they already have a lawyer, and that's what they're accusing her as far as the misconduct.
Let me take you one step further. And it sounds like Becker may have provided information to Jane that was privileged communication, her and R. Kelly.
Exactly. So violating R. Kelly's attorney-client privilege. That is not to say that the allegation is true, but an attorney who may be perceived as having engaged in that type of misconduct suffers from a per se conflict. Since the attorney cannot be free from fear that a vigorous defense should lead the prosecutor trial to, or the trial judge to discover evidence against her own wrongdoing. We've already said that like 50 times in this motion. All right. Second, when Ms. Becker formed an attorney-client relationship with Jane, her interests diverged from the defendant because she also owed a duty of loyalty to Jane, the government's key witness. Ms. Becker was placed under inconsistent duties because of her representation of the defendant and Jane, an adverse witness. Prejudice must be presumed where Ms. Becker had at least one extended conversation with Jane about her relationship with the defendant and may have obtained privileged information from the file that Jane's prior attorney sent to Becker at Jane's request. However, Becker was prohibited by the attorney-client privilege from disclosing any information she may have received from the conversation with Jane or from her prior attorney's file, even if that information would have been beneficial to the defendant's defense. Similarly, as the government suggested, Jane may have obtained privileged information from Becker. So here's the issue. So they're basically saying another part of the problem is that, she could have gotten information she never would have gotten if she didn't represent Jane, and then could have shared it with R. Kelly. But if she never represented Jane, she would have never gotten that information.
I don't agree with that entire section. And the reason is, if you're representing Jane and R. Kelly, for whatever reason, you've done it. And you say, hey, Jane, can I tell R. Kelly this? Of course. Okay. Conflict solved. Problem over.
Exactly.
Because you have the ability to do it. And again, I don't know how this hurts R. Kelly. It may hurt Jane, but she's not the one.
She's not the one with the Sixth Amendment right at this point. All right. Courts have recognized that where a lawyer seeks to simultaneously represent a defendant and a cooperating witness in the same criminal proceedings, a conflict of interest exists. But that's not exactly what happened here. She wasn't a witness against R. Kelly at the time that this lawyer represented her. Further, whenever a defense attorney has previously represented an important government witness, there you go, who testifies against the client, the possibility of a conflict of interest exists. That's what we have here. The defense attorney previously represented an important government witness who testifies against the client. There's a possibility of conflict, and there may even be a conflict, but it was waived. With these principles in mind, Ms. Becker suffered from an actual conflict of interest that could not be waived. That conflict was imputed to her trial partners. We don't have to get into this. Just basically, if you have a conflict, it can be imputed, meaning if I have a conflict, Pete's got a conflict. Pete can't keep working the case, and then I could not. Okay. So I'm sure there have been a ton of comments coming through that I haven't seen at all because we've been looking at the document. So now we're going to take a second to scroll through some of the questions and comments and get to that. Let's see here. And if you have any questions and you haven't put them in the comments or the chat at this point, put them in there because we're going to go through here. So Monique Dawn, shouldn't the conflict of interest have been resolved prior to trial?
You think? I mean, that would be the purpose of having all these hearings. Frankly, if I were the court and he thought that there was a conflict, that would have been the time to just shut it down. Tell the lawyer that at this point, I think there's a conflict. R. Kelly, this could come back to bite you. And if you want to go forward, it's at your peril. And I think the judge probably did that.
All right, let's see what else we got. Yeah, Anthony talking about maybe if it was just one juror, but not so many jurors saying these negative things about R. Kelly. Yeah, I did a whole video on that, and I know Pete's got some thoughts on. Why don't you give your thoughts on kind of how crazy and horrible it is that those jurors were allowed on his jury?
There is a concept.
What's up, Smoke?
Yeah, there's a concept of strategy, and the strategy basically says if it's a strategic decision for the lawyers, it's not. You can't make it a point of contention because I decided strategically I was going to let something go. When you've got multiple people saying they have a bad perception of your client sitting on that jury, it's no longer strategy. It's just an absolute failure to get those people off that jury. I can't imagine why they wouldn't do this unless they think for some reason they're trying to set up an appeal. But let's be real. That's not where you want to win the case. You want to win at the trial, not at the appeal.
Grant, the Jussie Smollett sentencing breakdown where I go through and watch and react to the entire judge's comments and sentence is dropping right after this, directly after this on our channel. So stick around and you'll see it. Yeah, thank you, Ms. Mans. Let's see, what else about R. Kelly here? Shawty, if the R. Kelly case is overturned, can they still hold him in jail until his Chicago trial?
Yes.
Yeah, especially if it's a motion for new trial, they can still hold him in jail. And now if he gets the judgment of acquittal granted, which I break down with another special guest, which we'll play next week, and that was a 60-page thing. We haven't even finished it. We've only done part one. But if it's a judgment of acquittal, that may be different. Then it'll depend on what's going on in Chicago.
Right. And Chicago probably has a hold on him anyway. So even if New York releases him, they'll still hold him for Chicago to come pick him up.
Beverly Alpha, I saw Reels is airing a documentary, R. Kelly, His Friends Speak, this Sunday night in which they discuss his slew of sex crimes. Seems like Hollywood is making it tough for attorneys to do their job. That's what I'm saying. Like we talked to Elizabeth Holmes, Ghislaine Maxwell had to deal with it. R. Kelly's having to deal with it. These Hollywood productions, they absolutely can have an effect on these criminal cases.
Absolutely, because it affects the public's view, and that's who your jury is. But what's really interesting is they'll talk to anybody, right? R. Kelly's gardener speaks.
Yes, exactly. And it's really something. And back in the day, we used to, even when I first started, and I know I went to some of my dad's trials as a kid, and he would ask if you saw the newspaper articles. And people would say, I don't get the newspaper. So then they didn't have to worry about them reading any of the articles about a high-profile case. But now it's like, do you have Hulu? Do you watch YouTube? Because you're going to get all this information about all these cases that could be slanted. It could not even come in a trial. You could already make your opinion up, which is why we talk about so much that you guys are all potential jurors. If you ever are on a jury, you got to put all that aside. You got to stay away from as much of it as you can to come in and just make a decision based off what you hear at trial. So do you think he has a chance at getting a new trial? I'll give my answer first. I think his only chance is based on the ineffective assistance of counsel during voir dire, where those jurors were allowed on if his lawyers didn't do everything they could, which we talked about in that video, to keep them off, to strike them for cause, to use a preemptory challenge, to ask for an additional preemptory challenge. That's his best chance. I don't think he's going to win based on the conflict.
I'm kind of tending the way you are. I think the fact that they knew about these jurors and just If they would have asked them questions and decided to keep them, that's one thing. But to completely ignore them, I think, is going to be the reason for the new trial.
All right. So that is the end of the R. Kelly discussion. Thanks, Pete, for coming on. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.